Hi, everyone. This is Behind the Screens. Today, we've got two faces that should be widely familiar to most in and around the DIFC, Shiraz Sethi and Thenji Moyo, representing DWF, a law firm that sits within the DIFC and is engaged in all things COVID-19 as it relates to the law and changes that are happening in and around the COVID-19 space. You might be aware that there was a release of a directive which kind of shakes around how employers and employees relate, and specifically to COVID-19. And I thought it might be a good idea to talk those changes through with Shiraz and Thenji. So perhaps, Shiraz, you could start by telling us what is happening in the DIFC.
So as of the 21st of April of this year, the DIFC have released a new directive. It is a Presidential Directive number 4 of 20, which deals with COVID-19 measures. We were actually part of a working group which the DIFC put together in relation to drafting the legislative framework. And that took a period of 3 weeks, and we put that together with the DIFC and the working committee. And as you can see, this has been launched as of today officially, although retrospectively it starts from the 21st of April and will continue until the 31st of July, or until such that the DIFC president will inform us of.
So naturally, people will be concerned about what this directive contains and how it affects the masses that do work within the DIFC. Thenji, could you touch, please, a bit on that for me?
Yeah, sure. This directive has brought in what we would consider sweeping changes for the COVID-19 precautionary measures period. Employers are able to adopt a number of emergency measures, which has already been done, ensuring employees work remotely, restricting access to workplace. But the most important developments that I think many people in the DIFC are more concerned about is the fact that employers are able to, during this difficult time, to impose temporary salary reductions to employment contracts. Now, this is what we understand to be quite a drastic measure, but balanced really with the fact that the overriding objective is for the DIFC companies to be able to sustain business operations during the pandemic. So what we see with this directive is, if you like, a balanced approach, looking at perhaps the long-term future of companies and employment in the DIFC. Companies are simply able to inform their staff that there will be reductions to their salary without consent. They're also able to impose annual leave restrictions with or without consent. So if, for example, and we're already seeing this in practice, depending on the business, we're seeing many companies telling their employees that, look, you're going on annual leave for a period whilst business operations have slowed down. So those are the main key introductions by the directive.
And I can imagine a population of DIFC employees who would be concerned that these arbitrary or seemingly arbitrary measures could be quite subjective. What protections would an employee have against perhaps unfair treatment?
Yeah, so we see quite a balanced approach, actually. So there has been some protection for employees. The directive introduces protection for any employees that have contracted the coronavirus, where someone has been issued with a medical sick note to basically say they have corona. They are protected. None of these emergency measures that I went through previously can be imposed on any of those employees. So that's quite interesting to see. The DIFC usual sick pay is 60 days, 10 days full pay, and then 20 days half pay, and then the other 30 days unpaid. So now you see a situation where any DIFC employee who has contracted the coronavirus or has been placed in forced quarantine by the local authority has added protection, and they will be on full pay during that time. So that's quite useful. You also find that we have been receiving a lot of queries from clients in the DIFC asking about whether they can reduce their workforce. So those would be considered terminated employees. Anyone who's been terminated after the 1st of March is really considered a termination because of COVID-19. So where there are employees that have been terminated, there are some protections that have been put in place by this directive. The employer must continue to provide at least a basic medical insurance, which is quite useful, and also employees can keep the visa going. So the usual position is is after 30 days, their visa can be cancelled. So now we're seeing that the authorities are taking a more relaxed approach, and the visa and the basic medical health insurance should continue.
Given the disparity in wages within the DIFC between the high earners and perhaps your retail employees, hotel employees, and so forth, what protections are being offered perhaps to the lower earning employees? Because it must be quite frightening to think, I'm out of work, I'm out of income, where will I live, what will I eat? And we don't have a social system over here that makes provision for that.
Really good question. We do see that the directive has considered that. We have seen protection in the retail, service and hospitality sector specifically, where these industries tend to provide company-provided accommodation. So where an employee has been terminated in those sectors, the obligation to provide company accommodation remains. So that's quite useful. What we also see is that the DIFC has also suggested that where companies have surplus employees at this time, or any terminated employees, they have provided the Government Services Office to put together a database, so a DIFC employee available database, where these employees will be listed with consent. So the employees must give their consent before their details are posted on the database. Now, the advantage of that is any DIFC employers looking to recruit during this time can simply approach the Government Services Office and look at the database and inform the office that they want to recruit off the database. So that's quite useful during this difficult time. And I think it will also encourage DIFC companies to perhaps collaborate a bit more than we do historically. We also see protection on end of service gratuity, which has always been a big thing in this part of the world. Shiraz and I, we volunteer at the Pro Bono Clinic in the DIFC, and far too often we come across employees who simply haven't received end of service gratuity because the business has gone under, because of hardship. And, you know, we are pleased that there have been initiatives such as the DIFC Employee Workplace Savings Scheme in the DIFC, which is looking to really protect the accrual of end of service gratuity. So what happens in this directive is where the employer has imposed a salary reduction, the end of service gratuity accrual is not impacted. So the end of service gratuity will be calculated at the salary that the employee was on as at the 29th of February 2020, because the directive really considers this period to start on the 1st of March. So we're seeing some positive protections for employees in the DIFC, which is good to see.
Shiraz, given how unprecedented this season is, you know, I hope for every generation to come that they don't face circumstances as we have in 2020 with COVID-19. We obviously need to survive as businesses, as employees, as families, and so forth. What I wondered was the way forward. So with everybody sort of trying to protect their earnings, trying to protect their livelihoods, and businesses trying to survive, what would your recommendation be for anyone sort of wondering what next?
Well, it's a common question that we are getting asked now, given that a lot of employers have been going through COVID-19, and we're seeing some light at the end of the tunnel with announcements being made through the government authorities around sort of getting back to some degree of normality, even though it may well be in a phased approach. I think the first and the most important thing is, as per the directive, before you take any of these measures, you must give the employee notice. And that notice is stipulated as 5 days. And that is very, very important, because that will give you the time to basically speak to the employee, explain to them the situation. It may be financial hardship. It may be that the business may go under if they do not take these sorts of steps, and therefore really sort of engaging with the employee for them to understand why such decisions are being made. So I cannot emphasize that enough. Consultation with your employees is of paramount importance. I think secondly, all companies have sort of introduced their business continuity plans. Some of these may have been stuck in the drawer and not necessarily, sort of been used forever since they've actually been drafted or renewed. And so a lot of people have actually had to pull those out, or not actually draft business continuity plans. And I think now, given the fact that where we are in this process, there will be a need to actually update those and revise those in terms of how now to police the sort of going back to work and going back to some sort of normality. So again, we are helping a lot of our clients with their BCP plans and sort of implementing sort of strategies and policies and procedures to ensure the safe return of employees back to the workplace. We're also looking at a number of other documents. So in terms of announcements and notifications, we're helping a lot of our clients with those. We're also providing return to work forms. And I think that's very, very important in respect of employees coming back and ensuring that employers are looking after the health, safety and well-being of their employees by ensuring that certain questions are asked from a medical perspective and also in terms of testing. And I think this is going to be sort of the norm going forward where, you know, temperature checks are taken for employees coming back to the workplace. I think the sanitization is going to be maintained. Social distancing for at least a period of time will continue. So these are things that employers must consider and maintain going forward. I think one of the other key points that are coming out of these measures and sort of especially the ability to return to work is that given the government measures are around sort of doing this in a phased approach, we're going to need to look at, well, which employees are going to actually come back to work. And the DIFC are very clear on the discrimination provisions that they have within the jurisdiction. And so, for example, if there are certain groups of high-risk people, for example, the elderly, or people who are sick or ill, or the people with young children, or someone who's got, you know, contracted a particular disease. These are groups of people that may not necessarily be required to come back straight away. So again, have an objective selection criteria and ensure that those people that you are bringing back to the office are well and it's safe for them to do so, and do not put yourselves in a situation where potentially you may come up with a discrimination claim against you.
So with employers and employees inundated with information, I think there is a risk of slippage where people may not pick on the nuances of this new directive. What is the penalty for non-compliance?
Well, that's a very good question. From our perspective, the board of directors of the DIFC from time to time can bring in some general workforce directions. With that in mind, employers who do not comply with such directions could be fined up to $50,000. Similarly, employees who fail to comply with these directions could face immediate dismissal.
Thank you both ever so much for your time. That's most informative. I'm sure you're going to get tons of questions on this from both employers and employees. How can they reach out to you should they need your support?
Yeah, we're happy to help and answer any questions in relation to this groundbreaking directive. We are very active on social media, so you can follow us on LinkedIn, send us an email, give us a call, but we're happy to help. Thank you so much for your time today.
Thank you both very much. Do take care.
You.